Hi, this is Mamita Rahman, the immigration attorney helping you navigate the complex world of immigration. In today's video, I will discuss what to expect during your removal proceedings. The first time you appear in front of a judge for your hearing in immigration court will most likely be very scary and bewildering for you because you may not understand why you are in removal and you will be afraid that you'll never see your family again if you go to court. But the first thing that you should know is that the first time you appear in immigration court, you will not be deported. You cannot automatically be deported without a hearing and a trial. And fortunately, we still have some due process protections in place, which means that ICE, the agency that alleges that you should be deported from the US, must actually prove that you are deportable. You can only be deported from the US if an immigration judge orders that you should be removed, and this whole process from start to finish usually takes a year or more. So, what happens during these potential several years that your case will be pending? You will have two types of hearings in court. The very first hearing you will have is called a master calendar hearing, or a master. This type of hearing is more like an administrative pretrial hearing where you will tell the judge whether you admit or deny the charges against you, and you will also tell the judge what defenses you are setting forth to protect yourself from removal. Then the judge may either schedule a second master calendar hearing, or they will schedule the final hearing date for your case. Pro tip: if you have not found an immigration lawyer to take on your case, ask the judge for some additional time so that you can find a lawyer. Most judges are usually understanding of the fact that you need to be represented, so they will give you a short period of time to get legal counsel. However, most judges will not allow you extra time more than once or twice, so make sure you don't wait to contact a lawyer if you receive a notice to appear. If the judge is ready to schedule your final hearing date, they will schedule what is called a merits hearing, which is also known as an individual hearing. So, what will happen at your individual hearing? The individual hearing is your final trial, and it is where you will defend yourself, present witnesses, and provide evidence, and make your arguments against being removed from the US. In court, you will be called a respondent, and the respondent almost always goes first in an individual hearing. Your attorney will conduct a direct examination of you, where they will ask you open-ended questions regarding your case and your defenses and why you should not be removed. The Department of Homeland Security's attorney, also called ICE counsel, is in charge of proving that you are removable from the US. And after your direct exam, they will ask you cross-exam questions. The judge may also ask you questions at any time. Once your attorney is finished questioning you, they then may decide to present witnesses or experts in your case to help further your defense. At the end, when everything is finished, the judge will either issue a decision in your case and consider the case to be over, or they may decide to give you a written decision by mail. This means that you may not find out for several weeks what your final outcome is. If you find these videos helpful, please subscribe to my channel and hit that notification bell to be notified when my next video appears. This has been a video on what to expect during removal proceedings. If you find yourself in the position of defending yourself from removal in the US, please give us a call to get set up for the consultation so that we can represent you in court. I'm Mamita Rahman, the immigration attorney helping you navigate the complex world of immigration. See you next week. This video is for informational purposes only and does not constitute legal advice. For proper legal advice on your case, please call us to set up a consultation.